Welcome to Who Wrote That Up for You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And welcome to Who Wrote That Up for You. I'm Sonia Ebron, a co-founder at Courtroom 5.
And I am Deborah Sloan, the other co-founder at Courtroom 5.
Got a delightful show lined up for you today. In a few moments, we will speak with Natalie Knowlton. She is founder of A2J Ventures, a wonderful project to work with entrepreneurs working in the access to justice space. So very excited to speak with her about that. Before we get there, Deborah, what is on your mind today? What's the news of the day?
I want to talk a little bit about the case that the U.S. Supreme Court heard back in, I think it was early December or late November. It's a case regarding redistricting. Specifically, there's a North Carolina case that is up in the Supreme Court. It was a case that the North Carolina Supreme Court threw out because it was unfair. It was a very biased districting. So the the basically the Republican lawmakers are appealing to the um, the Supreme Court to limit the involvement of courts in elections. And it appeared that some of the Supreme Court, the more conservative members of the Supreme Court, were leaning in the direction of limiting some of the some of the restrictions or some restrictions on the Supreme on courts hearing election information or hearing election cases. And for me, I think that that is an issue that is, first of all, we have a government where there's a system of checks and balances, where we have um, three arms. We have the legislative, the executive, and the judicial branch. And to limit the judicial branch from basically reviewing election issues, I think it will be a huge mistake, and I think it's a step backwards.
It's interesting. We've seen here in North Carolina a lot of those issues over the years around gerrymandering and just trying to deny people the right to vote. It's just ridiculous, but increasingly happening around the country. I would, like you, hate to see courts limited in their ability to oversee some of those things. It's really about enfranchisement, making sure that people have a voice in who
Right.
represents them. And it seems like to me all three branches should be involved in wanting to see more of that happen, but it is what it is, isn't it? So
Mm.
the other thing I would mention, I really enjoy, particularly these days, listening to oral argument at the Supreme Court. And I'm always tempted to think, oh, they've got a great argument or they've got a great argument. And then I have to just step back and say, it doesn't
Mhm.
really matter. That's the best
Mhm.
arguments. It's the political positions of the justices, and that's really a sad state of affairs. That's the
Yeah.
saddest thing about our courts these days is that people are bringing their biases into making law, and it's just really unfortunate. But again, it's what it is, way it goes. But thanks for bringing up that topic. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. So if you're in court without a lawyer, or you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. At this time, it's my great pleasure to welcome onto the show Natalie Knowlton, founder at A2J Ventures. Thank you so much for joining us, Natalie.
Thank you both for having me.
You know, I've been so excited for a while to get you on the show and to chat about all things access to justice. I have to just note, though, we are recording this the day after the ABA Journal designated all three of us members of the class of 2023 Legal Rebels. And so just want to just congratulate you and all of us and the entire
And
class.
you too.
I think we're so happy to be associated with folks like you who've been doing this work for a long, long time, and the other members of the class. And so it's a tremendous honor for us. I have to call out Bob Ambrosi. I think I learned about the release of this news yesterday from his tweet. And he commented in particular, every time he sees the new list, he wonders why all these people haven't already been on the list, right? And so I really, really appreciated that. That's not true, more true for anybody than you. You have been at this for a while. Should have been on this list many years ago. So congratulations again for making
congratulations to you. Well deserved.
Fantastic. Likewise. Natalie, give us your background. Tell us how you came to create A2J Ventures, and then I want to hear more about the services you offer there.
Sure. So I am a classically trained lawyer, and I say that because I'm not a practicing lawyer, and I think that's important to some people. But when I went to law school, I knew I never wanted to practice law in the traditional sense. I was always interested in systemic reform and systems thinking and human rights. So I went into the more nonprofit path. I fell into a fantastic institute called the Institute for the Advancement of the American Legal System at the University of Denver, doing access to justice of all kinds in the civil justice system. So I very recently left there. Jess, who I know you had on recently, has taken the helm of our legal profession work there. So very cool, kind of 360 on the show. But now I'm with Access to Justice Ventures. I founded it, and it is designed to empower entrepreneurs in the justice space who are delivering scalable legal services. I'm particularly interested in helping entrepreneurs who are interested in regulatory issues, interested in regulatory reform, and interested in entering some of the new regulatory markets that are out there and that hopefully will be expanding soon. So that's just a snippet about me.
That's fantastic. Thank you for that. And so tell us about A2J Ventures.
Yeah, so this was a dream of mine for a long time. I loved my time at IELTS. I loved being in academia, but I noticed this real disconnect between people who were building on the ground and all of the research that we were doing at IELTS and elsewhere. A really, really valuable research. So I started thinking, how can I bridge that gap? And I increasingly wanted to be part of the on the ground solution makers. So I left IELTS to form Access to Justice Ventures to start providing some of those resources to people to understand things like how to get into the Arizona ABS, Alternative Business Structure Licensee Program, how to get into the Utah Regulatory Sandbox, and also for lawyers and traditional law firms, really trying to get them energetic and excited about the changes that are happening in the law as opposed to resisting them, because there are opportunities to partner with technologists and all kinds of legal services providers right now. And I really want to bring lawyers along with that title change that's coming. And it's here, but it's coming in other places.
Oh, absolutely. Absolutely. You know, I think you've touched on and created something out of a tremendous need for, as you say, lawyers and tech companies in the space to really move into these markets. And so congrats on that transition, and wishing you a lot of success there. We're going to be watching you grow. Let's step back for a minute, if we can, and just tell us what is access to justice in your opinion?
Okay, yes. So this is a really good thing to clarify, because when you talk with a lot of people in this space, as you both obviously know, access to justice to them means access to a lawyer. And you find that across the board. It's starting to mean maybe access to legal services for some people, but that means legal advice. To me, access to justice is far broader than that. So access to justice is for people who don't want to go through the legal system. It's having the opportunity to work through disputes in a somewhat quasi-sanctioned manner that is contributing to society as opposed to taking away, and Justice is also being out of the court. It's being away from lawyers. It's using information that's meaningful and deployable. It's being able to access whatever kinds of resolution to the problems that you have. And to me, it's beyond legal. Justice is just a small piece, or legal, excuse me, is a small piece of justice. There's a lot of pieces of justice. So looking at the legal issues and access to legal services is a small piece of access to justice for me.
That is, I hear it. I hear your human rights interest there in that explanation, and the systems thinking as well, right? Very, very important. Why is it important for people to have then access to justice in that larger sense?
Well, what are we if we don't have access to justice? Talk about fundamental rights. We could be arguing about access to, healthcare. We could access to housing. That's all justice. It's all interrelated, and every piece of different non-legal justice issue feeds into legal issues. They all have kind of social justice ramifications. So social determinants of health are all justice. And if we as a country don't have a functioning justice system, and we as individuals cannot access justice in a way that's meaningful to us, what are we doing here?
Exactly. What are we doing here? That is so real. And so, again, if we don't have access to justice, we really don't have functioning societies. It's what I hear you saying. I totally agree with that. What is causing the lack of access to justice? Why don't we have it, broadly speaking?
I think a lot of things, and probably some things that I'm not thinking of. But I think if you start back historically and look at how small the country was when we formed, when lawyers were lawyering way back when, the population was minuscule, and it potentially made sense to have a lawyer in every case. But we even know then that people weren't able to access the system. So the system that we have in place now is really a system that was designed for oppression, leaving marginalized peoples marginalized, and for people who had wealth. And it continues to be that system because it's the exact same system that we've had for hundreds of years. So that's, I think, the big reason, the kind of systemic reason, is it wasn't built to give everyone access to justice. But today, on the more kind of concrete procedural levels, I think it's a number of things. One, attorneys are expensive, and I'm not throwing attorneys under the bus, because I know that the cost of law school, student loans, cost of operating a business, malpractice, all of that is expensive. So these are systemic issues feeding into this, but that, doesn't get away from the fact that lawyers are very expensive, and most people can't afford a lawyer. And I'm going to talk about affordability for a second, because I think it's important. When we say that people can't afford a lawyer, we're making value judgments about who can and can't afford a lawyer. So if someone says, I can't afford a lawyer, that person could be making $80,000 a year, but have $300,000 in debt, $200,000 in a parental medical debt, and have childcare to pay for, and be in a single home. So who are we to make that judgment that that person should be able to afford a full-scale lawyer? Now, I fully understand why we offer subsidized legal services to the populations we do, and you have to create that kind of income metric in order to say yes, eligible, or no, not eligible. But someone $4,000 above those federal poverty guidelines is not any more able to afford an attorney than someone who's on the other end of it. So I think that's, cost is a huge issue, and how we talk about cost is a huge issue. And then, just to be honest, the legal profession has a stranglehold on the provision of legal advice. And if you think about going to a doctor or going to the medical field, if I'm feeling sick and I have a fever, I'm not going to go to a surgeon. I'm going to call the nurse down the street, and I'm going to go in there, and I'm going to be able to, at an affordable cost, probably much faster than I can see the surgeon. And the surgeon's not going to see me anyway, because they're a surgeon. They don't want to deal with my headache, right? So we don't have that in the law, and we're starting to get there, but there's a lot of pushback, and it's institutional pushback, I think, because there's not an appreciation for the role that these new tiers of providers can play within the broader attorney ecosystem. So I've rambled enough. That's part of it.
You've got all the time on this show. I am not about to cut you off. That is gold. That's fantastic. Really appreciate that. And so, what are some of the barriers? You talked about cost, right? What are some of the other barriers to people having access to justice?
Well, think about where you have to go to get access to justice. So if you're talking traditional justice, you have to go down to the courthouse. Until very recently, courts were a place, not a service. And some courts kind of embraced the online, we're a service, we're providing justice. during the pandemic, but we're starting to move back into that, get your ass in court. You have a court date. That's problematic for people. People work. They can't get off work. The judges are not staying into night court in most places. So it's really difficult for people to even think about going to court. And, it makes maybe to distinguish between those cases where you have to go, for example, divorce, you have to go through the system to get that decree, versus a case that you have against your neighbor whose tree fell on your house and you're going to sue them. Well, most people just opt out of that because it's too burdensome. They don't understand the process. They can't get to court. They can't file. So I think just the structure of how we expect people to engage with the justice system, which is so judge, court staff, geocentric. We're not going to where the people are who need justice. We're expecting them to go somewhere to get justice. And I think that mind shift is part of the problem systemically.
Absolutely. You mentioned earlier some of the out of court opportunities to get justice. So dispute resolution, mediation, and so forth. Are there barriers there as well for people to get access?
Yeah, I think a lot of people don't know that they can do that. It's not like you have this popular TikTok mediation app, although I've thought about creating something like that to go where the people are. But people just, a lot of times they also want to resolve issues by themselves. They don't want to go to a formal process. Mediator sounds really scary. Attorney sounds really scary. And so they turn to clergy, they turn to other leaders in their community to resolve issues. And so that's part of getting justice, but the justice system also needs to appreciate that that's part of it and needs to engage with those community leaders to provide them with the tools that these people might need to get justice in the formal system.
Excellent. Yeah. So I'm hearing a couple of opportunities in your comments. You made the comment about middle class people not being able to get a lawyer and access justice that way. And wouldn't it be wonderful if legal aid were provided on a wealth basis rather than an income basis?
Yes.
Wonder if
Yes.
there's an opportunity for somebody. Let's just throw that idea out there for somebody to take up. Would love to see LSC propose something like that, for instance. Here also, though, hearing you suggest that courts reach out to community leaders to sort of extend the court as a service out of the courthouse. Is that happening anywhere, or are there any tendencies to make that happen?
Yeah, so I always throw Alaska in here because Stacey Mars, who's the administrator there, she's been with the court forever. She's fantastic. She did this really, really in-depth justice mapping program years ago now, where she, because Alaska's a big state, huge state, right? So lots of rural areas, lots of counties that don't have a courthouse. They just have a police station or a library maybe. So she mapped all of the justice partners in order to engage those partners in the common legal questions that might come up and arming them with information about how people can engage with the system. More recently, Minnesota worked with Go A2J Tech on Twitter. They're a dev shop and they work with legal aid and other courts for legal access to justice tech. And they set up a series of kiosks, 250 across the state of Minnesota, where people can go in and agency offices. There are some in courthouses, but they're outside of courthouses and community centers. So people can, for example, walk into a community center or a library, return their library books, and then start looking through this kiosk and think, my spouse wants to file for divorce. I don't know what that means. And they can access legal services there. They can even do court hearings in some of these places. So that's courts going to the community. That's actually allowing justice to be delivered where people are.
I love it. I love it. We need much more of that for sure.
Yes.
And so earlier you mentioned a couple of regulatory experiments in Utah and Arizona. There are some on the drawing board in other places around the country. What's the opportunity there for increasing access to justice?
Yeah, so twofold. One is on a provider level. And this is probably where we're seeing the most traction around the country. I think it's a little less, no, not a little, it's a whole lot less controversial for states. And this is the kind of notion of the tiered service providers, like the RNs to the doctors. And what these states are looking at, we call them at ILES allied legal professionals. So I'll just call them that here. Some people call them non-lawyer providers, but I'm not a fan of that term. And these providers are allowed to provide some level of legal advice. Now, it differs across states and across case types and across what they can do, whether they can go into court with a litigant or not. But they're allowed to take those cases where, for example, a non-contested divorce case where a lawyer down the street is going to charge $5,000 or $10,000. These parties know what they want. They just need help with the forms, and this new tier can come in and help them. So those are cropping up around the country in varying levels. Some are, for example, in Alaska, they recently enacted an unauthorized practice of law waiver for individuals working with legal aid. So that legal advice capability is going to be, pretty limited to that position, all the way up to these new 2-year associate's degree programs where people can provide legal advice to domestic violence cases, divorce cases. So it really ranges the gamut in terms of scope of the advice and then the licensure and regulatory requirements. So that's kind of the provider issue. But that we can scale somewhat with those types of services by changing the ecosystem of people who can provide, but you can't get to scale at definition with that. That's where technology comes in, and that's where the other piece I think is really important. So Utah, you mentioned Utah. Utah has what's called a regulatory sandbox, and that's a kind of ecosystem for experimentation with new regulatory rules. In Utah, they are specifically allowing relaxation of unauthorized practice of law and Rule 5.4. So those go together pretty closely and also tie into technology pretty closely. So Utah entrepreneurs now are able, if they can get into the sandbox, they're able to provide software services that err on the side of legal advice. This is, well, we're having this show right now as Josh Browder, right, is making national headlines and clearly under the gun from a lot of state UPL commissions. But there's a potential there, not what he's offering, but what real providers are offering that's safe, that's been vetted, that's tested, and that has routine reviews by an attorney. So that's the definition of scalable justice, is something that allows an individual to use and access their rights through technology in a safe and monitored way. And Utah is the only state right now that I know that is really, in the sandbox field. I think some states are considering it, but we're going to see how that shakes out. And I think a lot of opportunities can come out of that, and a lot of data that's going to show that we really should be allowed to do these kinds of things elsewhere in a measured manner.
Absolutely. Absolutely. I'm really happy to be in North Carolina for a variety of reasons, but we're one of those states considering some innovations in legal tech and the legal space. And so really happy to hear about what's happening around the country there.
Yeah.
And so you probably, in my opinion, have the best view on what is happening in the regulatory space and the legal tech space. What do you see going forward? How is this can being kicked down the sidewalk, if you will? What's it going to look like in 3 years or 5 years?
So if that were a movie scene, someone would be kicking the can down the street. Someone else would come, throw the can backwards. You'd go run back. You'd come up and get it, and then you'd fist fight, and then you'd throw it forward, and then repeat. So that's kind of what that shot would look like visually. But I think we're going to move forward. Longitudinally, maybe we'll go backwards and then move forward. But the momentum is there. And frankly, I think, so I'm all about public outrage. And I think we have the makings of some real empirical data to back that public outrage. And that's that these assumption-based regulatory rules that we have that are preventing the collaboration of entrepreneurs and lawyers, that are preventing people who can very easily provide legal advice at a certain level from doing so. I think we're going to have data that suggests that those are actually not empirically valid regulations. And so when you have other states and other advocates around the country saying, well, let's keep it how it is, I think it's going to be increasingly hard to justify that, because there's a concern, and always a concern, of public harm, and that's a completely valid regulatory objective. But that's not what current regulatory rules are doing. So I think there's a day of reckoning coming.
That's a powerful statement, Natalie. I'd be surprised if some regulators didn't come after you for that, right?
I would, yeah. I would expect that.
What are regulators doing then? If they're not protecting consumers from harm, what is this all about?
Well, okay, so we won't give regulators too bad of a name. There are some regulators out there, and they're going after any number of people. So obviously, the California State Bar is going after people like Tom Girardi, who did incredible damage absolutely incredible damage to the lawyer's name and to the clients that he harmed. So, that's valid regulatory policy. But they're also going after companies like Ticket in Florida, which was allowing software to review and then refer out to licensed lawyers. And they're going after companies like Upsolve in the Maryland Federal Bankruptcy Court. They went after Upsolve for, I believe it was a self-populating Schedule C on bankruptcy exemptions. Don't quote me on that, but something like that. So that court in Maryland in particular acknowledged that there was no consumer harm. In fact, it was the court that did the investigation, no consumer harm, and that Upsolve was absolutely living up to everything that they were trying to do, and it was completely valid reasoning that, why they wanted to be in the industry, and the court thanked them for doing what they do. So why are we going after someone like that? That doesn't make sense. And a lot of regulatory actions are actually not based on actual harm. There's no actual harm to be found. There's empirical research, limited, but there is some that shows that really you can't find actual harm of this, and that they're not brought by consumers. So these are lawyers bringing these, and they're not lawyers bringing them because they see consumers that are harmed. They're lawyers that are competitors. And that's what happened in the Ticket case in Florida. It was the traffic attorneys who went after this company, and they shut down.
Yeah. I was really sad to see that entire deal. And so your sense is that technology has, scalable technology has an opportunity to change things here, right? If you could dream it up, and I'm going to steal whatever you say, I'm telling you, I guarantee you, but if you could dream it up, what would the technology be? What would it do?
It would. So let me just reference a study, a kind of a basis as to why this is my dream. And very big, right? So let all the entrepreneurs figure out what this means. But Rebecca Sandifer, who really needs no introduction in the access to justice space, did a study through the American Bar Foundation several years ago now on access to justice technology, to tools out there. So she looked at the array of tools, and she found a lot of diversity. Great study, you should read it. But the thing that stuck out to me was that she found the biggest impediment in actually consumers benefiting from those tools is that gap between the information and the deployability. The diagnostic piece was missing in these tools because that's unauthorized practice of law. And that's what people need. You can put as much internet or as much information on the internet as you want at any given point in time. But if people don't understand how that applies to their situation, then there's a good chance that they're going to be lost in the system. So it's that diagnostic piece. What should I do? Should answer the should question. And I think technology, where it's appropriate and regulated, should be allowed to do that.
I do too. Absolutely. As I said, I'm going to steal that and try to stay out of trouble in so doing. So, fantastic. Natalie, I'm going to share your website here, A2J Ventures.com, and just, recommend that anybody working in this space who needs some help cracking open the regulatory barriers or other things in the space, reach out to you. Where else can people find you online?
You can find me at Twitter most of the days at Natal Alley Cat. That's NATALALLEYCAT. Natalie, I'm NAKNOW at LTON at A2JVentures.com.
Absolutely. Fantastic. Yeah. We'll share those in the show notes here. Just fantastic to speak with you about these issues. Thank you so much, Natalie, for joining us on Who Wrote That Up For You. We will keep in touch, as you know.
Thank you for having me. We'll have you on
again soon. Thank you.
Yeah. Let's go.
All right. Fantastic. Nice. I have been so waiting for that conversation. I'm just really psyched. I'm going to just transcribe it and just,
make it our own.
Make it our own. Exactly. A lot of quotables there. A lot of quotables.
Yes.
That's fantastic. Yes. So, Deborah, I know we've just got a couple minutes left here, but go ahead and tell us who won the last, or not who won, but what the answers were to the last quiz and what you've got teed up for next.
Okay. Is the following statement an exception to the hearsay rule? That was the question. A doctor testifies in court that an injured patient told him she ran a red light and caused the accident that harmed her. Yes, this can be an exception to the hearsay rule because it is a spur of the moment. Basically, it's called an utterance. And she uttered this statement, and he can then bring it to court as evidence. Okay, and today's quiz, interrogatories are Number one, sworn out of court oral statements. Number two, written questions sent by one party to the other. Number three, written request to admit the truth of certain statements. Or number four, a written set of questions a party at a ask a witness at trial. Which one is it?
Oh, I am so looking forward to seeing the answer. I often don't know the answers to your quizzes, but I know that one. I love discovery. It's the most fun, in my opinion, fun part of a case. Although none of
Good, because
litigation
it's
is
the
fun.
longest.
It is. It
Yeah.
is. It's the one you fight over the most. That's for sure. But
Yeah.
yeah, looking forward to seeing the answer to that. All right, fantastic. Well, that's all we have for you today. Thanks again for joining us on Who Wrote That Up for You, and we will see you next time.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.